Welcome back to Hacker Hangouts on a Saturday morning, and we're diving into the new DOJ CFAA. The Department of Justice announced a new policy for charging cases under the Computer Fraud and Abuse Act, which actually I can't decide whether or not it is a massive, massive change or whether it's a nothing change. So we're going to dig into that this morning. I have it up. I can share it out on the screen. And I want to first talk about kind of like what it is, what it kind of means, and then kind of where we go from here. So I'll start with just a summary of what happened. The Computer Fraud and Abuse Act, everything that's been acted on that is pretty much anything to do with unauthorized or unauthenticated or like scanning of the internet or security research, any abuses. Like you see those cases back where there's hackers, like there's Kingpin in front of the justices or within the presenting before Congress. Usually it's always impacting this act. So any abuse of that, anytime the DOJ went after a hacker, typically it was using this act. And they came out and they said, you know what? We're not going to prosecute good faith hackers, ones who are doing security research. So when I first heard this, it felt huge. But then when you read through the regulations and what the actual policy states, I don't know. Gary, what did I miss in just that quick summary?
I don't think you missed a whole lot. The CFAA is a very problematic law that most people in the security industry have rubbed up against in some way, shape, or form, and it behooves you to read it and understand it. And anyone thinking about getting into the pen testing realm or things like that, it's only in your interest to read it and understand why the law is problematic and why changes like this are helpful. But in my opinion, and we'll get to that, it's not as big a change as people think it is. But suffice to say, the problematic phrasing with this is that it states that people can be charged under the CFAA for accessing systems without authorization. Or actually, in fact, that's what if you remember the Aaron's law, that's what they were trying to get it replaced with. I don't know if that actually passed. That was in like 2013. The real verbiage in the act, I believe, is exceeds authorized access. Right. Yeah. So, and this is why one of the biggest jokes I've always heard was if I make a web page that says, here's a login screen, put in your username, but there's no password field, and then there's a login button, and you type in admin, but there's a little thing under the login thing that says only Gowrie may click this button, and no one else has authorization to click this button. Are you breaking a federal law? And so what you should extrapolate that to mean in many ways, and this is the way the CFAA has been leveraged by many large companies in the past, is by writing things into their EULA and user license agreement, they could functionally write federal law and make up felonies by nature of deciding, quote unquote, what is authorization and what is not authorization, or what is uh, exceeding authorized access. And the reason why I brought up Aaron, I think his name was Aaron Schwartz, who utilized a web crawler on a research database to just pull down as much public research as possible and then expose it because it was paid for by the government and it was public research. He was nailed with the CFAA and ended up, I believe, committing suicide while being held in jail due to prosecutorial overreach. And the problem with that is there wasn't really, he had authorization to access all of these things. He just exceeded access capabilities by utilizing a program to pull down all of that stuff instead of using a web browser. And so this service said, well, that was exceeding authorization. We don't allow people to use APIs like that. And that's really problematic, right? And so go ahead.
I was going to say is like even going a step further with that is you use the example of on a website where you just have a login. There's whole swaths of vulnerabilities within like OWASP or web pen testing where it's normal functionality, like directory traversal, or actually even easier, directory listing. A lot of websites are vulnerable to this. It's like, depending on what technology, it may be default or defaultly on. Effectively, this is like if you're in the folder structure and say you had like you were accessing a report, you go into blah, blah, blah URL /reports /blah, blah, blah PDF. If you delete your PDF from the URL, you're in the reports folder, and typically at that point, the web application should say, oh, hey, enter your report ID or your specific link. But every once in a while, it will just list all of the reports. This vulnerability was actually one, and people go, oh, well, that wouldn't happen. This was in Blackboard. This is like the college, the college university. What would happen is when you uploaded your homework, like for an exam or a report, and then you wanted to access it, you would go and you'd click your report, and then you could delete your file. And in that folder would listed every other student's document.
Amazing.
In that, you would go, oh, those aren't my documents. And they would say, oh, well, in good faith, you should have known. But what about normal operations that I delete that and all of a sudden I list everything? You're unauthorized, but how would I even know? And you got into an interesting part. I'm going to see if I can bring this up on screen. Oh my gosh, I love technology because it totally works every time. If you can see this is in the DOJ, the justice.gov website. And you mentioned something which is crazy to me, is that the things inside the terms of service could in some way fall under this act, which makes them federal law. And they use in this example, according to the policy clarifies that hypothetically CFAA violations that have concerned some courts and commenters are not to be charged. And this is the crazy thing. This is the examples they gave. I'm going to try and highlight it, but I'm looking at a website. Embellishing an online dating profile contrary to the terms of service of the dating website. Creating fictional accounts on hiring, housing, or rental websites. Using a pseudonym on social networking sites that prohibit them. Checking sports scores at work. That's insane. Paying bills at work. Violating an access restriction. Like, these things are somehow getting put in the same category as like security bug hunting research. Like, right?
Yeah. Well, and so this is kind of the thing, like bypassing. So I think their intent with checking sports scores at work is that a lot of work environments, corporate environments, put internet filters on, right? And so they have proxies, and people will utilize proxies to bypass them. This is stuff we did as a child. Like, it's easy. Bypassing those internet filters is trivial. Like, it takes 6 seconds of Googling to figure out how to do it, right? And that's, I think, what they're actually aiming at here is companies, and this is not hyperbole. I've seen it. Companies have said, if you do this, you're breaking the law and we'll call the cops. And it's insane. It's legitimately insane. It provides corporations the ability to functionally write the law with, no oversight whatsoever. That's what the CFAA, that's the problem I've always had with the CFAA. And while this is a move in the right direction. The reason why I say I'm not really like, I don't think it's a huge change is that while this may reduce the potential criminal liabilities for doing this work, it does nothing to change the the other one, civil liabilities, where if I'm doing research, and for example, the one I always like to pick up is DRM and cryptography in general. As soon as you run into DRM or cryptography, if you're doing this work, run away. Run away as fast as possible, because you will get your butt sued to the end of the earth. And there are criminal violations in the DMCA for bypassing DRM and various forms of cryptography. All you have to look up GeoHot, George Hotz, and see what happened with him with Sony. He was lucky not to end up in jail. If you go back far enough, the Sony, I think it was PlayStation 1, their original DRM, this is the idea of an illegal number, right? There is basically cryptographic keys are just numbers. And so if you share a certain number, because that's a well-known cryptographic key, it's technically an illegal number. You can't share it. So, Google illegal number if you want to know more. But yeah, so like that's why this policy change is good in the sense that I think the DOJ is essentially saying we're not just going to take unfettered direction from corporations on who to charge under the CFAA. We're going to have a special group that says yes, no. We're specialized in that. I think that's good. On the other side, you still have problematic provisions of the CFAA in the wording, in that it says exceeds access. And it just doesn't make any sense. Like if I like you just said, if I accidentally click on something that causes me to exceed access, I've caused a felony, right? Well, that's absurd.
Well, and something you said is like there's criminal and then there's civil. And like part of this, I want to get into the civil end at one point. And by the way, I flipped my mic. I'm going to just continue hitting it. It's just going to keep happening. Is on the civil side, like that part is just a gong show. It's an incredible mess, because you can sue anyone for anything because you don't like their nose. And there is something on the criminal side. This is where, like you said, you can accidentally, and people go, how do you accidentally hack something? How do you accidentally gain unauthorized access?
This one, only way I hack something.
I love, by the way, anyone who hasn't watched, oh goodness, like 2 weeks ago, there was another podcast, and you used the phrase, and I love it because I just had to edit it, which was I accidentally my way into all of software engineering when you were talking about your journey. But on the criminal side, we scope pen tests. We scope pen tests all the time. We looked at this one of our clients. That client uses AWS and they use Azure, and actually they use Heroku. So all of these servers are not their servers. The software is their software is. But if I test an API and all of a sudden say I just want to see like what SSL ciphers are they using? Like, are they using secure ones? So I enumerate those. Now, at that point, I'm not really hitting their software. I'm hitting their middleware, which they would install and they decide what they do. But say they use a proxy terminator or like a reverse proxy or like any number of load balancers which do SSL termination. Guess what? That's not their infrastructure. I am now testing AWS's infrastructure, and they require extra authorization. But it gets worse, because let's say, okay, we're going to scope that out. We're only going to test your application. So we're in their application right now. All of a sudden, they have analytics happening. They have Google Analytics. Well, I can't scope. I have to scope that out, even if it includes a vulnerability. I mean, I can't touch that. Well, all of their transactions go up to another third party. I don't have authorization for them, but the only way their application works is if I have that data. So either A, I need to scope out this piece and this piece and this piece, and then effectively I'm testing something that doesn't even work, or I test their whole application and kind of roll the dice and go, hopefully our statement of work will protect us. And it does. Like we have legal things in there which protect us. And, I won't go into the verbiage, but oftentimes, like you test anything, you are doing something illegal according to the letter of the law. And part of this whole DOJ thing doesn't cover any of that, because kind of maybe. What do you think?
I don't entirely agree with that. So like I do think this does change something. And the thing that it changes primarily is that they're basically saying intent is going to be number one focus on when we decide to charge under the CFAA. If the intent of doing one of these things was legitimately, security research, and there's basically they're pre-assessing reasonable doubt functionally,
Yeah.
right? Like if you're doing all this stuff, but then like you've been caught on the back end doing like finding vulnerabilities and then holding those vulnerabilities hostage unless a company pays you for them, like we
Mhm.
get into ethical boundaries there. And that's where I think the DOJ actually should step in and say, like, no, here's the ethics of the situation. You can't extort people, but you can do that, provide this as a service, right? So, and I think that's the important part of this, and I think that's what gets to the heart of the issue here is they're saying, by and large, we recognize there's a ton of security researchers out there that are concerned about these things. And what we're saying is, if you're doing business in security, and you're doing this stuff, don't worry about us charging you under the CFAA unless you are blatantly doing something illegal, which like that tends to be like, I know that's not very comforting in many ways because that the law is still technically on the books, but this, like, the DOJ in the past has done a number of things like this. Not to get political, but like the DOMA, or
Mhm.
with Defense of Marriage Act or whatever it was, like the DOJ comes out and says we're not prosecuting people under this anymore. Like it's
Yeah.
not it's not happening, right? And that does change policy. That does have major effects in the way that attorney generals' offices around the country actually look and try cases, right? Because that gets passed down to local offices and everything. So it's not that this has no effect. It's that the effect is going to be much more subtle than I think most people realize, because I think the DOJ was probably already going in this direction anyway. They're just kind of solidifying the opinion.
Yeah, I think the way you said it is like it trickles down. They make the declaration, and then they expect all the generals to then follow it and continue with it. I want to dig into good faith because someone in chat, Squiddy in chat says intention is in the eye of the beholder.
Yeah.
Is good faith exists in a contract, like it exists in the actual words of a policy. It exists in the summary. I didn't include the links of these two, the DOJ below. I'll include it after the stream or after the live, just so you can read through them. They're both relatively short. The entire policy is pretty short. The summary is short. Like, grab a good cup of Ethiopian Yirgacheffe coffee. You got your afternoon planned. The good faith, though, is something exists in the contract, and it means exactly what you mean, without ill intent. Like if you're doing this without ill intent, the problem comes in again. I think where this actually the line of this entire policy falls, which impacts a lot of us, is between the software and the networking layer. And I know I don't want to get necessarily technical, but if you're doing security research on open segments of the network, the policy is very clear. If you do unauthorized access, unauthenticated access, if you access a system which explicitly says, and I'll have to find it in the policy and pull it up and highlight it, but it explicitly says, if you are not authorized to access, if that little term and condition says you're not supposed to access this, if it was made clear that you shouldn't access it, you can't. You can't continue to go into someone else's system and test it. I think the part this majorly impacts is software testing. When you jailbreak an iPhone, when you pull down code from the internet and you can test it locally without impacting someone else, like the terms and conditions, which say like you can't decompile it, you can't reverse engineer, you can't do all of these things. Criminally, you can still be charged civilly, and we'll get into that. I think here you can't be charged criminally, and I think that's the big change. Is
Yeah.
that locally,
Well,
if you're testing in your local environment, your lab environment, you're pretty much in the clear. But the moment you start doing live testing on production QA systems that someone else hosts, you're in clear violation.
that was basically already the case. Let me share some. I don't know if I can share a specific window. Yes, I can. So this is
Oh,
from
it
the
came up.
actual
I'll see if I
comment.
can pull it up.
Yeah. Yeah, cool. So this is from the actual. That's your screen.
I know
Maybe you can't
it's
bring it up.
flipping on over.
There we
Watch this. I
go.
am a professional.
Happening.
Wait.
One more.
We're doing this all live, and it's
Yeah, we have no idea what we're doing. I could just
magical.
read it too.
Yeah, how about you read it? I'm gonna probably drop me
right.
and you off this thing, and I'll. Wait. There's a
Oh,
swap button somewhere here.
well, anyway, I'm gonna end up putting this link in the thing.
There we
So
go.
I'm just gonna read it. So what
I
this
got
says
it up.
is the department, and this is from the actual justice.gov, and this is the comments on this. The department will not bring quote unquote exceeds authorized access cases based on the theory that the defendant's authorization to access a particular file, database, folder, or user account was conditioned by a contract, agreement, or policy, with the narrow exception of contracts, agreements, or policies that entirely prohibit defendants from accessing particular files, databases, folders. Basically, what this is saying is what I said. Like, you're not going to get charged, and by this, it used to be that you would be charged first, and then all of this would be dealt with in court. They are flipping the policy on that. They are going to say, if you want charges brought, you have to go to this special group over here that will review whether or not this is an exceeds authorization justification, or if it is based on actual criminal intent. And unless you can show that it was intentfully criminal, in with a preponderance of evidence, I presume, which is like it's more likely to have been than not. Like, basically, you're trying to prove that it was not, or at least you have to show a willingness to disregard many things to show that they weren't doing a good faith security research.
Mm-hmm.
Unless this group agrees with that assessment, they're not even going to bring charges, which is a complete flip from the way they did many of these things in the past, which was, this company claims that they did that. Cool. Let's do an assessment. Oh, look, the contract says if you exceed authorization, here's the act they did. Here's what the contract says is the authorization. Cool. Done. Charged under the CFAA. Move on to the next thing. Right. And then they'll deal with it in court. This is flipping that on its head. And that is very important. Right. And the important part here is the DOJ is actually saying that exceeds authorized access is a problematic statement in the law that needs to be changed. That's what's critical in this, is that the DOJ is looking at the law and going, this is problematic, and we can't just charge people because it's wrong. And it is like a flag to lawmakers to say, you need to change this because this language is at issue. It's giving corporations and it's giving private entities too much power over the government to have an effect on individuals' lives. And and now we can talk about all the civil issues, but that's basically what I'm trying to say here. That is, accidentally shoplifting versus maliciously shoplifting. It's kind of funny. Kind of like there is a difference. Like, technically, it's not shoplifting if you accidentally walk out not having noticed because you lacked intent. Right?
Mm-hmm.
You had good faith to buy it. You just walked out with something by accident that you haphazardly put in your pocket. Right? It's evidence that you did it, but a matter of criminality is a matter of intent in many cases.
Again, like we definitely separate these though. This is criminal charges versus civil. Like, I want to get into civil because I think that one's interesting because that one ties into responsible disclosure or full disclosure or any of these things. And I think this is kind of going to affect some of that, because when it comes to like good faith disclosure, like this is the act of doing it. So like, I guess this doesn't necessarily change. And again, I guess it's probably worth saying we've looked over this. We're not lawyers. We haven't consulted a lawyer. Don't like do silly things. Like, ultimately what's going to, I'm going to just keep hitting my mic. Ultimately, what is going to save you in any of these cases is don't do dumb things. Like, if you feel you're doing something stupid, stop. Especially if you go, hey, I have now crossed into this like realm of I'm hitting someone else's server. I'm doing something. Ultimately, if you were doing stuff in your own house, cut off from anyone else's network inside your own lab, you're more than likely fine. And I wouldn't necessarily worry about it. But the moment you go outside your network is when it starts getting a little hairy. Do you have something to add there?
Three things. No, it's just three things in this realm. One, if you feel like you're doing something stupid, take a step back, reassess what you're doing. Two, don't talk to people. Don't talk to the police. Don't make statements. Like, they could just be used against you. It's bad, right? Keep your mouth shut. And if you're doing this work, have a lawyer.
Yeah. I think that's
those three things. Keep your mouth shut and get a lawyer.
I think that was actually, I don't know if you've ever seen, there was a video where it was a prosecuting attorney talking to a college course, and it's like an hour and a half long. I'll include that link in the description down below after like we're done live, because that's another one everyone should watch. That was just singularly, we'll throw it in chat, but if you haven't watched that, go watch that, because that changed my thinking, especially when it comes to like, even keep your mouth shut. If you ever find yourself in one of these positions, any position, you can do no good opening your mouth. But okay, let's go over to civil, because I think that is an interesting piece, because I think this thing, while not criminal, let's lay the groundwork. You can sue anyone for anything. I can say, Gowrie, I don't like your beard. It is much fancier than mine. I'm going to sue you. It will go all the way through. It will probably just get rejected in court, but it doesn't stop the lawsuit, and it doesn't stop him from having to, push back. He can come back after me for frivolous, and he can come after me for the expenses, but the lawsuit will go through, and I can sue him for this. So there's nothing stopping these things. They have to assess damages. But I think this is why the CFAA was designed the way it was with criminal activity. Because if I do security research, let's say I found Log4j. And again, I know we're getting into the whole full disclosure, non-full disclosure. But if I found Log4j and I secretly, that's an open source. Let's pretend Log4j was closed source, like something like that. If I secretly told them, they go ahead and they patch it and they push it out and they push patches all the way out. In theory, that protects that company the most financially. Like, if I found a massive critical vulnerability and I broadcast it out to everyone, they're a publicly traded company, their stock, it's going to take a hit. Versus if I secretly told it and they put it under the rugs and no one did like a diff on the patches, like. And I think that was the intent on some of the CFAA, which was
not even close. Not even close. The CFAA is an antiquated law from 1986, prior to security on computers ever really being a thing, right? The intent behind CFAA was to give the government an incredibly large hammer to deal with a hacking problem, because they did not understand hacking at the time. That's why, like, Hackers the movie is kind of a meme now. And the Hacker Manifesto, if you read it today, it kind of reads like a meme. But at the time it was written, no, the CFAA was this massive thing that if you touched a keyboard that you weren't allowed to touch, CFAA criminal violation, right? It was a huge hammer that they passed, and it only became more problematic over time. So that side of it, what the DOJ is starting to move towards is like, oh, we actually have a much bigger security issue that we need to deal with, and these people are trying to help us. We need to actually embrace that, right? On the civil side, what you're trying to get at is responsible disclosure versus open disclosure, whatever it's called. I think it's open disclosure.
I think it's public disclosure.
Public disclosure. And the argument is basically, well, responsible disclosure prevents damage in two different ways. It prevents, adversarial people from getting access to exploits or exploitable vulnerabilities before they can be patched, which protects people. And it also protects companies from financial damages, like you said. And public disclosure is a way of a giant level arm of saying, fix this or you're fucked, right? Mm-hmm. Right. That's basically the debate. And basically saying, like, well, this is, public disclosure on this. Responsible disclosure says, like, I can go to a company and say, I found this, I'm going to publish it. I don't want anything for finding this unless you're offering me something. That's fine. But I don't want anything for offering you this information, but I'm telling you, I am going to publish this on this particular date. You have until that time to contact me back and work with me and tell me that's not enough time to fix it, or I'm going to release it, and you have to deal with the that's what or that's basically the definition of responsible disclosure, right?
It
Public
does
disclosure is just forcing a company to do it.
It does tie back to this, though, because there's a section, and I'll see if I can pull it next time you're talking, which talks about extorting the company. Now, extorting is obviously a much larger term between like, I'm informing you of this vulnerability versus I'm extorting you for money. But this is a whole nother piece. Like, if they have that, company doesn't have a bug bounty or things like that, all of a sudden, like, it can very much feel like extortion. Like, again, and I think this is where good faith is going to come in with so much of this, is whether or not the person was acting in good faith. I think they're not going to. I have a feeling with this act, you're going to see more and more good faith used when it comes to civil cases as well. I think they're going to start going under that, because I think hacking, even like the word hackers, when you use them with the general population, they immediately think of, the bad actor. And I think we're going to start applying good faith to more and more cases, not only criminally, but also civilly. And they're quickly get thrown out if you're operating in good faith, pending that they're going to have to, I think, align that with what type of disclosure you're doing. Does that make sense?
Yeah. No, I agree, right? Like this aligns with telling people, and the extortion portion of this is actually very critical, right? Because what I said was responsible disclosure is going to accompany, with or without a bug bounty. Let's say they have a bug. Let's say they don't have a bug bounty. If they don't have a bug bounty, if I were to go to a company and say, I have found a critical vulnerability in your infrastructure that, puts all of your users at potential financial harm, and I say, I am going to release that information in a month unless you contact me back and tell me whether or not you have time to fix this, and I'll work with you on the public disclosure portion, or I'm going to release it publicly. That's not extortion, because you're not asking for anything. If in the process of saying that you say, I will release it unless you pay me X amount of money, that is extortion, because now you're causing someone damage unless they give you some amount or something in return. That is a form of extortion. If I simply say, good faith, I'm trying to help you and protect your users, you have this vulnerability, work with me or I'm going to release it, that is a way for you to operate in good faith towards the people that are susceptible to it, right? And like, this is the legal theory that the EFF and others would proclaim, right? And that this is the legal theory that most, I think, software entities hate the most, because it puts them at the highest level of responsibility for dealing with this. So the DOJ's statement here, being very explicit about that extortion case, is basically telling companies, if someone comes to you with a bug and it's responsible disclosure, that's your problem. That's not our problem. Don't come running to us, right? And that's a way of reducing the workload on the DOJ for stuff that honestly isn't their problem.
I'm curious if so much of this is, it does feel like we're at a pivotal point, and maybe getting a little bit away from the DOJ stuff. I feels like we're at a pivotal point when it comes to security research. And I guess I'll tie it back to, what was it? 2 weeks ago. No, last week. I started going back and forth with Gulo on stream, where he was saying, this is just when we go client server, it's just a repeat of everything in the past. And I argued that, because I said, no, I think we're getting better at knowing what parts of what layers of the stack go where. For instance, browsers have become much more powerful, so we're pushing a lot of the client-side stuff over there. Not client-side security or anything like that, but we're moving more of the code on over there. I think and the reason I bring that up is because as we move code around, more and more of that code might become available to security researchers. I feel like we're at a pivotal point, though, within security, which the whole industry feels like it's going to tip one way or another to fully embrace. We'll say, not open source, because open source is a whole nother, but like open intelligence gathering for vulnerabilities with more established bug bounty programs. And they're going to do that because they realize we do this for the fun of it, or we do it for money, and we need to get paid. And this is, I think, what we've noticed within bug bounty programs, you often get bug hunters focusing on that software more. And then the ones, and because they have very much, here's the established path of how you communicate vulnerabilities to us. Here is the payouts. Here's how we establish it. Versus the ones who don't, you're kind of left like some of the vulnerabilities that I found. You're kind of left like there was one within a utility. I put in my address to pay my bill, and all of a sudden I saw my address come back in my browser. And just for the fun of it, I'm like, okay, what happens if I throw a single quote in there, not SQL injection, cross-site scripting, saying, can I run JavaScript in my own browser? And found it. I wanted to notify the local utility, but here's the thing is, how do you reach them? Security at thecity.org? Like, it's just guessing. And I think in good faith is going to continue to protect this as if you're not extorting it, if you're not doing this. I think good faith is also going to be protected within bug bounty programs. So I'll spin this to the question, which is, do you think that this is going to shove more companies to this, a more like understanding, we'll say, that to promote good faith hacking, this is how we're going to establish it. And then everything outside of that happens is not good faith. Because they can show like a pattern. Let me say it this way. They can say, anyone submitting this exact way is good faith. Anyone who's not submitting in this way is not good faith. Do you think that that's kind of where we're shifting?
So I don't know that it's going to fall out exactly to that level, because trying to get every company in the nation to implement such a policy is, and then you're going to have like 5,000 different ways that are the appropriate way to do this. It's too much of a burden on the individual security researcher to apply to all of these different standards of good faith. It's just what you're saying is just a way of subverting the DOJ's opinion on this, which is to say the DOJ is going to look at this and decide whether or not good faith occurred. The company will not be the one to decide whether or not good faith occurred. That's why they were explicit in stating their contract's statement on what is exceeding access is irrelevant to the CFAA. The DOJ will decide what is good faith and what is not. That's really what's being stated here. And so I don't think it's going to fall out quite to that level of granularity, but I do think that this opens the way for entire companies to be created whose only job is to go out and to seek bug bounties. And it's going to create, well, I mean, like that already basically exists to some extent. You know, most pen testing companies are kind of like that, but I think we're going to see more build up as a result of this, because it clears the criminal path where you don't have to worry about that to a huge extent. Whatever, lawyer you get in can point at this memo and say, like, you're in the clear because this is good faith, at least criminally. Now we have to deal with the civil side.
I think I go back though. This will massively impact software bug bounties, like anything local. I think it's not going to open up the doors to anything which requires a server. Like if you're testing without explicit bug bounty programs, you're not going to be you're not able to test live endpoints. Like Google actually has a list in their bug hunting. They have a list of, here are the endpoints you are allowed to test. Endpoint meaning like a URL, an application, maps.google.com. Here are the ones you're allowed to look for vulnerabilities in. Don't hit anything outside these. These are the ones authorized. But I think this will not protect pretty much any interaction with a foreign system which requires any semblance of authentication or authorization, and you're not explicitly told to test this is criminal. Like that is that lines it. But software wise, anything local in your system, I do think this opens the doors for.
I mean, I'll get into this in a second, but I do want to point out the language in the actual comment here, which states, with the narrow exception of contracts, agreements. I removed it, but I can put
That's
it
all right.
back up if you want. With the narrow exception of contracts, agreements, or policies that entirely prohibit defendants from accessing particular files, databases, folders, or user accounts on a computer in all circumstances. So what you're stating is basically that if the bug bounty says everything here is free game. Oh, and this is the thing though, is that contracts, agreements, or policies, right? Just because you access a website doesn't mean you agree to their EULA, right? That's the thing to remember, right? So the idea here, and yeah, that's where there's still some gray area, and that's why the CFAA is this antiquated pile of garbage that needs to be replaced with something much more explicit. Is that there's so much wiggle room for the DOJ to decide what is intentful criminal activity and what is not, and bring a case against somebody and functionally ruin their life just by bringing the case, right?
I guess.
But so I don't know that your statement in saying that like these bug bounties are going to be written in that way, and that's the only way you're going to be able to do it. The DOJ comment basically says if your things are publicly accessible, those things aren't going to hold for us to bring criminal charges. They may hold for civil, hard to say, but the DOJ isn't necessarily going, because if it was legitimate, security research with clear good faith intent, then it's not really going to matter to the DOJ in that sense.
You've said
I
this.
say that that's an opinion, just to be clear. That's my opinion.
So something you've said a few times, which makes me kind of start laughing, is I realize as we're talking, when I'm thinking about this change in the CFAA, I'm running it through like everything in life. I'm running it through my own sieves of going through each one, going, okay, like what does this mean for the testing I've done? What does this mean for this? What does it mean for this? And what's interesting is you keep saying it's antiquated and it's old, and it just hit me as we're talking. In the movie War Games, this is the one which he was brought in front of the court for, was, I believe, the CFAA violations. And I'm thinking back to War Games.
Oh.
Heck, it wasn't?
No. War Games predates this law.
Really?
Yes.
Oh, that's funny.
Yeah. War Games predates this law, and in fact, like, I'm not going to say it was responsible for this, but it was definitely in the zeitgeist around the time that this was passed, right?
Oh, that's funny.
That type of scaremongering around hackers. Like, that's why when I said the Hacker Manifesto is kind of one of those things we laugh at now, but back then, like, the commie scare was the Red Scare was still very much a huge thing. And, hackers in this sense were seen the same way. Like, they were lumped into that same, that they even say it in the movie Hackers, where it's just like the beauty of the bud and all that stuff. And you're like, man, that's cool. And the other guy goes, this is commie bullshit, right? Like, they all got lumped into one giant thing. And I'm not going to say War Games was partially responsible. That's not what I'm saying. What I am saying is that it was part of the zeitgeist at the time to say that all hackers were bad, and War Games predated this, and they pointed at examples of, well, if something like that happens, we don't have a law in the books that allows us to criminally prosecute them. Therefore, we need the CFAA, right? Like, I'd have to go look at what was going on in Congress at the time and take a look at C-SPAN maybe, but like, I guarantee you that was part of the
it wouldn't surprise me, though, because you look at other things within how media has impacted law. And I use the example, like, without even necessarily like diving into it, like silencers, when they banned all silencers and things like that. Like, I think most people thinking about silencers is this pew, pew, like James Bond like thing. They're not quiet. Like, I think like at the DEF CON, they have the range thing, and I think they had one there, and I remember hearing it going like, this is super loud. Like, this doesn't necessarily change it, but it was passed because of media impact. So that while that one is like a kind of an odd one, but like computer impacting it, it's it's the deep magic when they don't understand it and they're passing laws for it. I think where I was,
Yeah, I mean that's basically it. Go ahead.
where, oh no, I was thinking when I was thinking through the sieves, is I'm thinking about the scene in Hackers where like oftentimes I'm thinking like present day, we know authentication is a thing and authorization is a thing. Like you need a username and password to log into things. And like present day, if you can access a system without a username and password, it was either intentfully created that way or someone screwed up. Back then, though, and I've said this on stream before, what are we doing now where we're going to look back and go like, these people were crazy? But like back then, you just dialed into systems. Like you punched in the number of the system, put the phone on, and then you're on that network. Like there's no necessarily security and for some things. Again, like you just connected to the system. You just telnetted on over and immediately had access. And then that's where those authorizations saying you're not authorized to have this access to the system. There's no username and password protecting. It was just there. And I think we're going back to this mentality of like, this thing is now being applied present day. And I think you've not that I was never against you on this one, but I think I'm starting to realize how antiquated this thing is. It really does not apply to present day.
Yeah, and kind of to bring in a little of the civil side and then to also say what this doesn't do that is also still problematic is there's this combination of the CFAA existing and the DMCA, Digital Millennium Copyright Act, and very explicitly DRM and cryptography and anti-circumvention. So one of the things that is not addressed, as far as I can tell, inside of this DOJ opinion is the assessment of what is considered criminal liability for circumventing DRM or copyright protection or things like that. And this is one of the most problematic portions of these two laws combined. Because, and the reason why I said if you ever rub up against, cryptography or DRM, just run away, just drop it, unless you have like very explicit permission from a company to attack those particular things. You're opening yourself up to a world of litigation by touching those things. And just go look at the guy who made the Nintendo Switch DRM bypass thing. He got multiple years in jail, and it was like millions of dollars of and I'm not going to say like his intent was to enable people to engage in emulation and to bypass DRM. Like his intent was not what do they call it? A good faith intent. His intent was to subvert a company's ability to make money by allowing people to steal games. That was his intent. And I'm not saying that he shouldn't have been prosecuted for enabling that. What I am saying is like that's on one extreme side. However, the law is worded in a way, and this is where I got to the illegal numbers, where if you find out that somebody's DRM is garbage, and that if you just type in like if you just type in a particular thing, or you're able to demonstrate that you can crack these things, the moment you tell someone else that you have discovered this and how to go about doing it, you have committed a felony. Even if you're communicating with the company that has implemented this, if you have distributed that information in any way, that's a felony. And that's why like assessing DRM and cryptography and anti-circumvention software, you should not touch it because it is a legal minefield because the combination of these two things. And if you want more information, I we could do a whole stream just on the DMCA and breakdown. I would need to have some notes in front of me for that. Mm-hmm. Something I studied very intentfully while I was in college. And I was surprised to see what I found when I got there. I was like, wow, this is terrifying. Like I want nothing to do with, I'll just say I've had multiple times in my career where I was asked to assess something that had a DRM key attached to it. Mm-hmm. And I went, no, I'm not touching that. You all can do that, but I'm not touching that because you're asking me to commit a felony. And
and what's crazy about that too is your company doesn't protect you on that. It's not that they won't protect. I'm saying it would be like if I like when I was at General Electric or something like that. It's like if they told me to go kill someone, like and I go kill someone. It's not like, oh, well, the company told me to do it, I'm all right. No, it is in that same category, which is terrifying. I think oftentimes, especially within pen testing, like, or physical security or anything like that, we go, oh, but I have my get out of free jail card. I have like, there was the case with the two pen testers from, I think it was like Coalfire or something like that, who like broke into a federal building. And it was like, that one was just a complete mess of scoping and things like that. Like there was,
you may have your get out of jail free card, but it doesn't stop the security guard from shooting you.
yeah. Oh yeah. Like that one was just, oh gosh, that one was just like a complete mess of, okay, I'm going on. You need like 20 seconds here, because like this is why scoping is incredibly important. If you're going into the pen testing field, if you're going into bug bounty, if you're going to anything which you work with another company as a consultant to do, you have to scope it right in something that every single company has. The security at a big enterprise, security gets it in their head that they are like, oh, but where's security? Like, I feel like I should do the voice modulator because I just have one now. But like, where's security? We're super cool. We want to keep all of this. And they do like things like social engineering, like phishing, and they go, we're going to do this inside and not tell anyone about it. We're going to do a pen test of their application and not tell them about it. We're going to go do this and not tell the rest of the company about it because we want it to be a real world. We're going to have our red team break into this segment of the network, and we're not going to tell them. Within an enterprise, sure, why not? But the moment it does like DRM, like you could win the you could win the battle with your red team. You'd be hired to do this, and you will never do work with that company again if the developer of that one doesn't like that and brings it up to their CTO. They say, we're never hiring this company ever again. Criminally, though, same thing. Your company says, oh, it's fine, go test DRM, and you do it, you committed the felony, not the company. You are liable
Just to be
for
clear,
it.
Go test someone else's DRM. Right. That's the thing that I'm stating. Like, if I was working at a big company, we'll just say Microsoft, for example, and I was tasked with testing Microsoft's DRM, that's one thing.
Oh, yeah.
If Microsoft goes, here's a server stack, assess the Cisco server. Oh, it's got DRM on it. Don't worry about it. Just test that too. No, I'm not touching that. Unless you get me a thing from Cisco that says I can touch that DRM and try to subvert it, not touching it. Touching it, because it's not only is Microsoft. I'm using this as an example. I'm not saying this happened. Just to be clear, But like the company that is telling you to do it, yeah, they would be criminally liable for doing that too. But all of the people who engaged in the activity as well on the team would be criminally liable for doing it. Right. So it's not that you have this umbrella protecting you because someone else told you to do it. It's just that you are both criminally liable in that situation. And I've had those situations where I've had to point out, it was like, that's not our DRM. I'm not touching it. Stop asking me to bypass it. I'm not doing it.
I always laugh, by the way, the moment either of us say, I haven't done this, immediately everyone's going like, oh, they've definitely done this. And it's like, there's no way around this. Like, I'm going to state it right now. I have never gone out into the field and spray painted a cow blue, but I have the story about it. And everyone's like, I definitely don't wear a kilt, but my shirt definitely says I'm wearing a kilt.
I'm
just kidding. I'm not actually wearing any pants right now. Go on. You're actually wearing.
You can always assume I'm wearing a kilt. Michelle was just telling me, my wife was just telling me, she's like, you need to get non-patterned kilts so you can wear patterned shirts because you look ridiculous right now. I'm like, yeah, I should, which goes against everything I've said before because I am like, go plaid or go home. And I'm like, yeah, maybe I should get a solid color kilt so I can wear plaid on the upper half.
Oh my gosh, it's kind of incredible.
Sorry,
by the way, Melissa didn't actually found this shirt. I am so proud that this shirt is a thing. And anyone who's just listening just to the audio, it has says the word beard and points up and kilt and points down. And if anyone finds an old image of Gowrie, he was definitely wearing a kilt at DEF CON 29, and you can find that image somewhere online. So
Uh,
go. I think like I wanted to kind of look at this from a summary. Is like what do we gain from this? And I think the next phase is like what would the actually you know what we've talked about DOJ enough. What does the ideal state look like? Like we're in the perfect world. You're God, you're the king. You can pass whatever laws you want unilaterally, just you, don't need the approval of the people. What would you do in a perfect world to fix this problem?
Man, I'm not a lawyer. I couldn't tell you. Like, drafting laws is so incredibly difficult because language has to be interpreted by someone else 20 years later, 30, 40 years later. Like, we're looking at this, probably made total sense in 1986. You're asking me to change the law in a way that will make sense 40 years from now when technology is completely different. I have no idea. I mean, I think I could help consult on that, but what I have learned in studying some small, I'm not a lawyer, some small amount of law within this area specifically is that language as written in a law is different than language written in common parlance. And I am not eloquent enough to be able to state this is what we should change explicitly. I will say, though, that the direction the DOJ is going is recognizing the root of this issue, which is that we need to get away from laws that allow corporations to functionally tell the government a new felony exists, right? Which is what this exceeds authorized access mechanism allowed companies to do, which is to say, arbitrarily defined authorized access means whoever defines it gets to decide whether or not a felony has occurred, right? And the DOJ is saying that's not the case anymore, or at least we're trying to claw that back. And I think this is in the right direction. I do think when Aaron's Law tried to change this. Let me look up the wording on that. They tried to change very explicitly one portion of this to change it from. Closed it already.
Are you pulling it back
They
up?
tried to change I got it. The Congress tried to change the wording in the CFAA from exceeds authorized access to access without authorization. And that actually is a very clear change in wording, in the sense of if it is a publicly accessible resource, you have authorization to access it, right? As opposed to exceeds authorized access provides corporations the ability to state arbitrarily what a public access person is authorized to access. It changes the law so it says that if you can do this, you're not going to be held responsible unless there was other criminal intent involved. And I think that's like just the change of those three words would be sufficient to change a lot of dynamics within the security industry. Is it perfect? No. That's one thing that I would change.
I think when I'm looking at this, I think I like their use of good faith. And I think this is going to have to expand into other realms civilly. Criminally, I think it was, while it was a small change, it was a big step in the right direction of acknowledging the problem. Just like you said, you acknowledge the problem and they're trying to fix it. I think they understand that it's squishy. Like the idea of good faith, the idea of, or like, I didn't even say good faith, that the idea of putting it down in writing, what authorization is, what authentication is, and especially like authorization is getting so much more difficult lately with like things like passwordless in keys. Like if you screw up and put the wrong key on your application server, it might be able to interact with things that it wasn't supposed to be able to intent to, but it's still, in theory, authorized access because you're using, I hit my mic. You're still using their authorized key to authenticate and authorize to other ones. So I think what we're going to see is this continuation of using the word good faith when it comes to hacking. And I think we notice this more and more. Heck, even in media, whether it's war games or hackers, like hackers, as much as we keep coming back to it, as we'll call it memedom and whatnot, like they were very much good faith hackers. Gibson was doing something it wasn't supposed to. It wasn't a good thing. And then what they were doing is they were good faith hacking. And I think we're going to see this start at the criminal line and slowly move over to the civil. And I think that is, we'll say, a solution moving forward. What do you think?
I think that the takeaway from this should be that the DOJ having to submit this opinion and change separate from Congress is a problem, right? Because the next president comes in, changes the head of the DOJ, they can change this opinion. They can change this opinion. They can change the way that they decide to do this. So what I will say is elections have consequences, as we've learned this week, and that people need to vote for representatives that are willing to change the laws. I don't think this is a solution. I think this is a Band-Aid that allows the DOJ to put a lot of work that they had on their desk off their desk and not prosecute garbage cases. But that doesn't mean that the DOJ can't go back on this opinion. So I think it's important. I think what you stated is in some ways correct, but I don't think this is a solution. And I don't think this change is sufficient. The law has to be changed to reflect the opinion in this, to reflect this opinion.
Yeah, I would agree. I think we're still dealing with antiquated laws for a technology which is massively exceeding and changing. And you bring up a good point. You're writing laws that you have to think about what is the impact of this law in the future, and even more specifically, what precedent is going to be set on top of this and reference back, and laws get built on each other, just like a contract. You have this piece of the contract, and every piece of precedent builds on top of that. And at a certain point, you can't change that without changing everything else. This has been a lot of a conversation. I think I want to say thank you for joining us, but what is your last word, Gowrie?
Vote. Vote for your life. That's my last word. Vote.
As always, thank you for joining us. Thank you for diving into the DOJ and another Hacker Hangouts. Thank you for watching. And as always, hack on.